So I think we're good now then, right?
I think we're good.
Yes,
Okay.
ma'am.
All righty. And John, we're streaming then, right?
Yep, you're all set.
Okay, great. So good evening. I call to order the Policy Committee meeting of Monday, March 21st at 7:01. The first policy up this evening for review is Parent-Teacher Communication, RPS Policy 1110.1. The last time this policy was revised was 4609. It was in the Shipman and Goodwin Fall 2021 policy update. It is a required policy as noted by CABE, and it's also mentioned in the 2019 audit. If you take a look first at your Shipman and Goodwin version in front of you, as per the Shipman and Goodwin Fall update, the red line revisions to this policy comply with Public Act 21-46. One, it offers parents the option of attending parent-teacher conferences remotely, and two, to conduct an additional parent-teacher conference during periods of remote learning in certain instances. That language and revision can be seen at the bottom of page 1A-B. Also, the new law requires that school districts collect certain emergency contact information and provide, after January 1st, 2022, a document to be developed by the State Department of Education concerning educational safety, mental health, and food insecurity resources at any parent-teacher conference required during a period of remote learning. And that language and revision can be seen at the bottom of page 1C, and then the second page, last paragraph. Since this policy hasn't been updated since 2009, I do think it's a good idea that we go through by paragraph. For me, just to start looking at the current policy, it lacks a how-to in my mind. It talks about being a knowledgeable partner in the current policy, and it's under communications, parent involvement, but yet there's really no distinct method in the policy that clarifies how to be a knowledgeable partner and communicate and involve parents. I do believe that the Shipman and Goodwin version should replace this because it sets the stage for parent-teacher communication and therefore really fosters how parent involvement through communication is crucial for our students' achievement, which is mentioned in the last line of the current policy. So I actually have two recommendations, two edits to the first paragraph for this committee's consideration. So if I could just read the first paragraph of the Shipman version. The Ridgefield Board of Education, the board, believes that parents should be knowledgeable about the education that the public schools, the districts, provides to enrolled students. And then an edit for your consideration. One way the board believes that parents can be knowledgeable is when they have regular communication with teachers. And then since this policy is about communication and parents, I thought to add another sentence, something to the effect of parental involvement through communication is essential to improved student achievement. Therefore, it is the policy of the board to encourage parent-teacher communication. You know, I think for me, just the added language that I'm recommending, I'm trying to bring together the being knowledgeable and then also the communication involvement parental piece that this policy falls under. I would love to hear any feedback on my recommendations or other edits. Ken?
I think that there's probably some way to combine the sentence that's there that starts "the board believes" with your second sentence, so that we're not saying parent communication, parent communication, parent communication. I think it's important to repeat it, but I think 3 times within 3 sentences is a lot. But to begin your beginning, I would say the board believes that one-way parents are most, and just start that sentence with the board. But I think if we can combine those two sentences, I think, because we repeated the same sentiment twice in those two.
Okay. So you would start the second sentence, instead of with the words one way, you would want to start it with the board.
The board believes one way.
Okay, so the board believes one way that parents can be knowledgeable is when they have regular communication with teachers.
I would say are most knowledgeable. I would say.
You would say most knowledgeable?
Yeah, I would leave that, leave that there, because that is the best way. That's how you're going to get the most knowledge about what's going on in the classroom, is regular communication.
Okay, one way. Okay. So the board believes one way that parents are most knowledgeable is when they have regular communication with teachers.
If you wanted to, if you feel strongly about including one way, I don't know that we need to distinguish it, because then what are the other ways? If we say one way, what's the second way? What's the third way? Are we going to rank the ways?
That's a good point.
I think the point of it, and again, the point of this whole policy is the parent-teacher communication.
That's true.
Just a thought.
No, that's a fair point. Anybody else have any feedback?
Rachel, would you mind just repeating the second part of your sentence?
Sure. The second sentence that I was thinking of inserting was parental involvement through communication is essential to improve student achievement.
What if the sentence, the board believes that parents are most knowledgeable when they have regular communication with teachers, and if you then just made that statement, that second part of your second sentence, and therefore it is the policy of the board to encourage.
And therefore,
I think if you do the comma after with teachers.
Okay.
Put the essential. That phrase.
Gotcha. So the board. So the board believes. Are we good with one way, or do you want to take out one way? Now with what you said, Ken, now you have me thinking.
Well, I would take out one way only.
Okay.
I was deferring to you. I take out one way.
Oh, because now you have me thinking, which is good.
No, I know. I did it.
So the board believes that parents are most knowledgeable when they have regular communication with teachers, which is essential to student achievement. Good. Any other feedback on that?
I'm good.
I could read it again. Good. Okay. All right. So the board believes that parents are most knowledgeable when they have regular communication with teachers, comma, which is essential to student achievement. Okay. Awesome. Thank you. Good work, guys. All right. Looking down the first page, are there any questions with the second paragraph? Just going through it, since it's been so long. It's been since 2009. In the Shipman version, any questions there?
Nope.
Nope. Okay. In the third paragraph, I did a little research myself. It says the procedures developed in furtherance of this policy may include monthly newsletters, required regular contact with all parents, drop-in hours for parents, home visits, and the use of technology such as homework hotlines to allow parents to check in on their children's assignments. So it's a may include list. However, just so for your notes, it is directly from Public Act 21-46. It's on page 21 of 43 of the Act. Some of those things in that list I thought could be a little outdated. I don't know, do we do homework hotlines? I don't know if we do that anymore.
No.
No.
Not that I'm aware of. That said, though, not a bad idea.
Right.
Well,
Just
right now we
do.
have drop-in tutoring that's virtual, but it's not a homework hotline. But help.
Yes.
We do Google Classroom, though, that tells parents what the homework is.
Did we want to add to this list and make it per Richfield?
Well, I was going to say maybe we take out the homework hotline and put in a reference maybe to Google Classroom or, well, Google Classroom I think would be consistent. I think we would keep with that. Do we have policies, procedures developed already? Is there a corresponding procedure document to go with this?
Yeah, I wouldn't necessarily say they're procedures per se, but there's practices. If anything, that's the language that I would use. We have a variety of different practices that we use to ensure that families are aware of what's happening in their classrooms and their schools. There's so much that's not here, right?
Right.
And it
whether
would depend on the grade level too. So kindergartners versus 12th graders, it's going to look very different.
Right. But I think the may include covers that. And is procedures from the statute, Rachel?
The procedures, yeah, I could check it again. Yeah, I know the wording from may include on was all in the statute. Yes.
So maybe can we just confirm that if it does say procedures in the statute, we use procedures, but otherwise
Yeah.
the practice.
I'll look now for you. I have it in Ken. That way I don't have to come back. I could tell you right now. It says these policies and procedures. Yes, it's there.
with all due respect to Shipman, or whoever created this public act, they don't work in schools.
No,
Because these practices
this is
change.
not the first or last example we'll see of that, I'm sure.
No.
Okay. So, did we want to add in anything like an online posted assignment / grades, phone calls, electronic communication, or, would the administration actually prefer it to be more broad and to leave it the way it is? That way we don't have to come back and change if we use something in the future other than Google.
Yeah.
Why don't you just say,
I like the latter.
I think if you just say the use of technology to allow parents to check on their children's assignments would be much
exactly where I was
cleaner.
I like it. But broad is almost all.
Take out homework hotlines.
Yep. The use of technology to allow parents.
You got it.
I think that's general enough.
You got it. Any other feedback, questions? Okay. So the next paragraph is what I was referring to when I went over the updates. This is all as per Public Act 21-46. For your notes, A, B, and C, that's on page 22 of 43 of the Public Act. Any questions?
How does the administration feel about this?
Well, it's part of Public Act. It's generally speaking fine.
Okay.
It does,
How about-
it's ensuring
how about
access.
specifically speaking?
Well, the reality is it's right. It's exactly what Corey just said, is this works for right now in providing access to families in a variety of ways. And I think the flexibility of it, holds us to a level of accountability that it's not just going to be one way.
Okay, great. So I guess we can move that forward then for a first read.
Well, what about that
All
last
right.
paragraph? I
Oh,
thought that last paragraph was rather restrictive. And is the document from the board, from the Department of Education available? Is this
Not
something-
yet. We haven't received it yet.
and that's only, to my understanding, too, if we're in a remote learning situation, that document would be given in a parent-teacher conference, I believe. Any
That-
questions?
Okay. Yeah, I mean, it does reference section B, right?
Questions, feedback? Ken, are you good with that paragraph, or did you have any other questions? Tom, do you have any other questions on that before moving forward?
In that last paragraph, where do you see that it's remote learning?
So it refers back to B, and B is to conduct the one parent-teacher conference in addition to the two flexible if we're in a remote learning situation. And in the Shipman and Goodwin update, let me just go back for a second here.
That is a little confusing.
So it is confusing because there's a lot of language, but basically what it says is that, so in the spirit of transparency, somewhere around 2010, the law shifted to these two flexible parent conferences. Now what they're saying is that in addition to those two flexible parent conferences, you would also conduct one parent-teacher conference when we've been, so I think what the spirit is here is that if you've been teaching remotely for 3 weeks in a row, you want to offer parents an opportunity to check in with their teacher, because the learning experience is very different than a traditional learning experience. So I think that's what the spirit of this policy is. So that whole two parent conferences flexibility is one piece. And then they're adding this other element that basically says, should you be in a remote environment for more than 3 weeks, you need to also offer one parent teacher conference to families so that they can check in, because what we've learned is that not every child responds in that environment. That was my takeaway, Rachel.
Yes.
Right. But then in addition, during that conference, you have to provide this information given to us by the Department of Education, correct?
Correct. Yeah, that's that last paragraph, right?
That's-
And I'm going to guess that they're not rushing to do that at this moment because they don't have to, but if they were like the rest of us, you'd have to chop, chop, have it done.
Right, but then on or after January 1st, 2022, talk about broad.
Yeah.
Right.
But
Because that's my point, Ken, is that,
Yeah.
you know, with us, we had to have the policies in place. With them, it's on or after. That could be on or after 2022,
it'll
2023,
be 2027. You're still in that window.
forever. It's the on or after forever.
Yes. Yes.
I mean, it doesn't tie us to anything, so it doesn't hurt to put it in.
No, and I think it could, you know, what it does do is it forces some level of accountability on the part of the state, because if we're in a remote environment within 3 weeks, we need to have something available to families. And to be fair, you would want that information to be relevant for the time, right? So if this happened 2 years from now, whatever document that the Department of Ed would provide us, you would want that to be relevant to that time period, not from 2 years ago.
Yeah. And I also like the big jump from 3 weeks to 6 months. Because, 8 weeks in is not going to make a difference, or 12 weeks in. But, okay.
All right.
That's the law.
We good there? All right, I'm going to move on unless someone can stop me, that's okay. All right, so the following 5 policies were unanimously approved on May 24th, 2021. But since that date, Public Act 2179 was approved on June 28th, 2021, which has resulted in the following revisions to these policies. So the first one up is Equal Opportunity Plan, Non-Discrimination, RPS Policy 0521. As per the Shipman and Goodwin fall update, the red lines in this policy reflect 1, changes by Public Act to the statutory definition of veteran. They also clarified that complaints can be filed regarding discrimination and harassment. And in light of the recent notice of interpretation issued by the U.S. Department of Education, Office for Civil Rights, they clarified that complaints based on allegations of discrimination or harassment for reasons such as gender identity or sexual orientation will be handled pursuant to the board's policies regarding sex discrimination and sexual harassment. If you take a look at the Shipman and Goodwin redline version in front of you in our current policy, the only difference is that our title is Equal Opportunity Plan, Non-Discrimination, and Shipman's is Non-Discrimination. So in looking at the Shipman version, you'll see in the first paragraph, the update, it says discrimination or harassment. In the second paragraph going down, there is no edits in that paragraph, but just for your notes, gender identity or expression, that's General Statute Section 1-1N. The next paragraph is the updated definition for veteran. So it was before, it said, for the purpose of this policy, veteran means any person honorably discharged from, released under honorable conditions from, and then the new language, or released with an other than honorable discharge based on a qualifying condition. So the qualifying conditions listed are A, they could have had a diagnosis of post-traumatic stress disorder or traumatic brain injury made by an individual licensed to provide healthcare services at the United States Department of Veterans Affairs facility. B, they could have experienced an experience of military sexual trauma disclosed to an individual licensed to provide healthcare services at the United States Department of Veterans Affairs. Or C, a determination that sexual orientation, gender identity, or gender expression was more likely than not the primary reason for an other than honorable discharge. Before going to page 2, any questions with page 1? Okay, page 2, on the top, there's no edits in that paragraph, but I mean, I find this stuff interesting. So this was the Crown Act, bill number 6515, just for your notes. The third paragraph down, this is the clarification of complaints. And then we have listed the different offices, and I don't believe that that information has changed at this time. Any feedback or questions on this policy, Ken?
So just to be clear, these red lines that are in the shipment are going to be inserted or made to our RPS policy.
Yes, correct. Correct. And then all of the individuals listed in our current policy, I believe all that information has stayed the same. Office for Civil Rights, Boston office, all of that information. Questions, comments? Good. Ms. Wing, do you have anything to add? Did I miss anything?
Rachel, you got it all. Thank you.
Oh, great. Awesome. Thank you. Okay, so moving on to the next policy, it's sex discrimination, Title IX, and harassment in the workplace, RPS policy 4118.1. So as per the Shipman and Goodwin Fall 2021 update, in light of the recent notice of interpretation issued by the U.S. Department of Education Office for Civil Rights, we have revised this policy and administrative regulations to clarify that Title IX prohibits discrimination on the basis of sexual orientation and gender identity. If you look at the Shipman and Goodwin version and our current policy, there are just a couple of things I want to point out. So the first paragraph of our current policy, the first sentence is actually the last sentence of the Shipman and Goodwin first paragraph. But then the rest of the paragraph is not Shipman and Goodwin. I'm fine with that. I just wanted to bring that to committee's attention to see if there's any feedback and or questions on it. And then in the second paragraph, that's where the new language would be inserted in our current policy, because the rest is exactly the same as the Shipman and Goodwin model. Discrimination or harassment on the basis of sex includes discrimination or harassment on the basis of gender identity or sexual orientation. Any questions thus far? Okay, just one thing, just a formatting thing that I thought we could change. If you move down our current policy, you'll see on the first page, it says discrimination and it's underlined. I thought perhaps as just a formatting, we could delete that and then highlight the words sex discrimination, just as in the Shipman and Goodwin policy, just so it matches, so that, you know, if it ever is brought back to committee again, it would be easy for the committee to make corrections. Is that okay? Okay. The second page of this policy, very similar. So underneath, second page, it says reporting sex discrimination or sexual harassment. That whole paragraph in our current policy, it is the exact same language as the Shipman and Goodwin version. However, the sentences are out of order as per the Shipman and Goodwin model. So it's just a formatting correction, but I would recommend to committee that we stay with the Shipman and Goodwin version and just put the sentences in order that appears in the red line version. But it's the exact same language, just different.
Which place was that, Rachel? I'm sorry.
Oh, hi, Selena. No problem. So on page 2, Selena, of our current policy, it says reporting sex discrimination or sexual harassment. So underneath that, where it says like violations of this policy, those two paragraphs are exactly the same wording underneath the Shipman and Goodwin version, where it says reporting sex discrimination or sexual harassment, but the sentences are kind of out of order.
Okay. All right. Sorry, I lost you because I was still looking at the other thing. So.
Oh, no problem. Please stop me, guys, if I go too fast, please. Ken?
I apologize if this was clarified earlier because I can't sound. But just on your formatting, we're going to, because I noticed also that harassment was a subtitle too. We're going to take that out also in the RPS policy.
Let me just see where it says.
Much like we did for discrimination.
I want to say yes. Hold on one second. To assistance, sexual harassment. Good catch there, Ken, because I didn't have that down. Thank you. So yes, I think we should do that too, so we can match it up. Thank you. And then we should highlight in our current policy sexual harassment under Title IX, just as it is in the Shipman and Goodwin version. Thank you. Good catch there. For that, any other questions? Page 2 here.
Sure.
Okay. those are all the things I had for committee on this policy. Are there any questions or feedback on anything else on this particular policy?
And those contact, the complaint addresses are all the same still. Oh, they should
Correct.
be recent. I'm sorry, this is a recent adoption, sorry. Not like the other one. Good.
Good, guys? Okay. All right, so moving on to the next, it's non-discrimination personnel, RPS policy 4118.11. So this policy shares the same updates as policy 0521 as per Public Act 21-79. So if you look at, let's look at the Shipman and Goodwin version first. The second paragraph, you will see or harassment, again, as per Public Act 21-79. You will see the updated definition for veteran on the bottom of the page. The second page of the Shipman and Goodwin version, third paragraph up from the bottom, that is the update to complaints. What I would like to do is just go back to page 1 for a second. I want to point out a couple of things that our current policy has that the Shipman and Goodwin policy does not have. So just want to make sure that we keep these things because we value them. In the second paragraph, where it reads the board's prohibition, it's like halfway down the second paragraph, of discrimination or harassment in its educational programs or activities expressly extends to academic, non-academic, extracurricular activities, including athletics, as well as the district website. So in the Shipman and Goodwin version, it doesn't say district website, but in our version, it does say district website. So I just wanted to bring that to committee's attention because there's just some subtle things here and there. Also, a formatting thing. So the next couple paragraphs in our current policy, they're all directly from this Shipman and Goodwin policy. They're just not in the order in which they appear in the Shipman and Goodwin policy. So I would recommend that we just format it to the Shipman and Goodwin version. So for instance, the next paragraph is on protective hairstyles, then it's genetic information, then it's veteran, then it's gender identity or expression. But in the Shipman and Goodwin version, it's genetic information, it's veteran, it's gender identity or expression, it's protective hairstyles. So just so that it's the same moving forward. Good. Ken?
Yeah, so I agree that it makes it easier going forward if there are other changes that we're not trying to compare. We're comparing apples to apples. So I agree with that. And back in that second paragraph, that is an interesting call out. It's an unnecessary call out as well as the district website, because it also applies to email communication. It also applies to a lot of other things, and why we're calling out the district website, because that already is part of the academic, non-academic, and extracurricular activities of the district. So I was just curious if there's any history on why that was called out.
Does anyone on the administration side have any history on that? Why to include district website?
I don't have history, but to be honest, I'm trying to pull back from 2021, Ken, when we revised this policy. I think that was the last time we revised it, right,
Yes.
Rachel?
Yeah.
I feel like we did have a long conversation about the website, and you know, I don't have Wes here, but the non-discriminatory practices related to the technology piece. You know, I'm just thinking about accessibility possibly and why we spent time on that. I can't remember exactly. but I would imagine it's connected to accessibility in some way.
Okay.
Okay.
Okay. So moving forward, next policy, non-discrimination students, RPS policy 5145.4. This policy also shares updates as policy 0521 4118.11 as per Public Act 21-79. So, and this policy is exactly, it mirrors the, our current policy mirrors exactly the Shipman and Goodwin version. So if you look at the red lines here, second paragraph, again, as per Public Act 2179, it adds in or harassment after discrimination. You'll see the updated definition of veteran in the next paragraph. And on page 2, you will see fourth paragraph down, the update to complaints. Are there any questions on this policy? Ken?
I'm sorry if I missed this before and I'm just not seeing it, but there is, what distinction are we making between gender, sex, gender identity, and sexual orientation?
In regards to,
I'm sorry, that would help. I'm on the last paragraph of page 2 of the shipment policy, right before the Office of Civil Rights Address. So I would say discrimination or harassment based on reasons such as gender, sex, gender identity, and sexual orientation, which isn't that gender/sex.
Birth gender versus how someone identifies, Ken? I think that's what they're trying to distinguish there.
But wouldn't that be the same thing? If I'm a male and identify as a male, that's my gender identity. But if I'm a male and identify as a female, or if I identify as whatever I identify as, that's my gender identity.
so it says on the top, a gender identity or expression means a person's gender-related identity, appearance, or behavior, whether or not the gender-related identity, appearance, or behavior is different from that traditionally associated with a person's psychology, physiology, thank you.
Physiology.
Physiology, or assigned sex at birth.
So then should
Right.
we
So-
make
so-
that distinction on gender sex then? The physiological gender or the assigned sex?
I think that it's understood because of the paragraph above. That's what I was referring to, Ken, is how, birth gender versus how someone identifies themselves as. I mean, you could repeat what's already above, but I think because it's on the same page, helps explain that.
Is it on the same page or it's on the second page?
I'm sorry, it's on the same page as
For the
it's on-
purposes of the policy.
yeah,
On the
shipment is on the top. And then the paragraph that you're describing is the second to last one, or the last one.
Okay, because then that first sentence of the second paragraph, gender isn't called out individually.
Ken, are you talking about the first paragraph on page 2 on the shipment?
No, I'm talking about the second paragraph on the on page 1, I guess. It is the policy of the board that any form of discrimination or harassment on the basis of race, color, religion, age, sex, sexual orientation, marital status, national origin, etc., gender identity or expression, or veteran status. So gender isn't called out separately there. It should just be consistent.
It's not, but sex is. So
Right.
in here, it says gender/sex, and then that's what I think they did.
So if what Ken is perhaps suggesting is that we just add gender/sex in the second paragraph, second line, just to be consistent, Ken? Are you?
No slashes. I'm vehemently opposed to slashes. Gender, comma, sex. Much like my Oxford commas. This is a
Gender, comma, sex.
But yes, to your point, your primary point is that I think.
So I think I mean, we could go either way, but what I think they're trying to do in the last paragraph on page 2 is that they can be synonymous, and that's why they're using the slash.
But they're not.
But I think that's what they're trying to do there. So if we don't want them to be synonymous, then I think we use the comma.
I mean, I think this is an ever-changing, like really quickly changing concept. And I do think the concept of assigned sex versus gender identity is really the updated distinction. Again, I do my best to keep up with it as much as possible. So I think the comma probably makes the most sense.
So then remove the slash.
And then
So no slash in between.
just a comma.
But I wonder if what I wanted to check though is 2179 and how they, I have here. Oh, here it is. Hold
What
on.
it's worth, I think we're overanalyzing this and we should leave it as it is. This is, as Dr. Hanaway says, it's an ever-changing area. I don't know what that means. If this is the way the lawyers suggested it, I'd leave it as is.
I would agree with Tom. I have up in front of me Public Act 21-79, so I was just trying to go back and to see, but I believe that is how they listed it the way it is here. But Ken, to your question, so you would rather not have a slash, you would rather have a comma. That's the point you're making?
That's an editorial choice. But if we are, but then we need to add gender/sex to that second paragraph.
Right.
And to Tom's point, with all due respect, lawyers don't always get it right, but we should at least be consistent. So if the lawyers think that the gender/sex belongs there, then it does belong in the second paragraph. Because it's literally the same topic.
Okay, would the committee feel comfortable? It's a 53-page document, guys. That's why I'm just trying to scroll. I apologize to find the list.
I'm okay with this.
Are you doing it too?
No. That's more of an editorial. For me, it's more of an editorial, like an Oxford comma.
So can we come back then to that? Maybe.
But I still think gender/sex should be added to that second. If we're accepting gender/sex, it should also be the policy of the board not to discriminate on the basis of gender/sex.
I mean, I'm okay with doing that, but then I just have to make sure that we go back through these 5 policies because it is a sentence in other policies as well. So it's in the 4118.11. I just want to make sure that if we do that we are consistent. Okay. All right. So I'm gonna make a note. Okay. Are there other questions with this policy before moving forward? Just in the essence of time. Okay. So the next one is, where am I? Okay. Gotta make sure this is sex discrimination, Title IX, and sexual harassment, RPS policy 5145.5. So this policy shares the same update as policy 4118.1. It revises the policy for clarification that Title IX prohibits discrimination on the basis of sexual orientation and gender identity. Our current policy and the Shipman and Goodwin version are exactly the same. You will note the insert that will happen in the first paragraph will be discrimination or harassment on the basis of sex includes discrimination or harassment on the basis of gender identity or sexual orientation. Are there any questions on this policy? Ken?
I just want to say, so maybe this gets to that point of where gender is a separate construct than sex, because if we're talking sex, harassment on the basis of sex includes gender identity, then that is a separate concept than from gender, which means it's not gender/sex, or it would say gender/sex here also.
Can you say that one more time?
Sure.
Ken?
So here, sex, they're defining it sex discrimination as harassment, or excuse me, including harassment based on gender identity. So it's not harassment of gender includes gender identity. It's sex harassment based on sex includes gender identity. So so gender/sex, they're not synonymous. At least they're not synonymous here. So if they're not synonymous here, why are they synonymous in other policies?
Oh, that's a good point. I mean, we could definitely add the gender slash.
But is that correct though? So are they looking at discrimination of gender is based on assigned gender? But what is the point of distinction that the lawyers are making? Because it looks like they're making two different.
Yeah, can I just give my comment, Rachel?
Yeah, absolutely, please.
Yeah, so for this one, they're specifically identifying identity, gender identity. The other policies did not say identity, it just said gender. And I think that's the distinction point.
Okay.
They all said gender identity though.
Oh, gender/sex.
Sex. So
Comma,
I think
gender identity. Comma, sexual orientation. But when you, but I'm saying when you have that slash, you're saying they're synonymous. That's what the slash means.
yeah, but I think I think they're different though, Ken. I think in that other policy, when they were having sex/gender, I think that they were referring to them in a synonymous way, where here, I think it is different. I think that the way in which they're identifying gender identity versus or sexual orientation is not the same way that they were defining, and I'd have to go back to that policy, sex/gender there. So I think there they were referring to the social construct of gender versus and I think let me go back to that one.
It's just 2 pages up.
I would probably leave it. I wonder if they had, I mean,
So, Ken, when we were, I think it was policy 4118.11. In the second paragraph, they didn't, for whatever the reason, they didn't use gender/sex there. And
Yep.
later in the second to last one, they use gender identity, sexual orientation, and gender/sex. But I still think that they're trying to use gender and sex there synonymously, and they just omitted it either unintentionally. I don't think it would have mattered. In other words, if you wanted to be consistent and you added gender/sex in the second paragraph, I think that would make sense because it's the same reference in the second to last paragraph. But when they do explicitly add in gender identity and sexual orientation in that policy to distinguish that from gender/sex. Am I making sense or confusing the situation more?
I'm understanding what you're saying, but it just in this policy, they're defining gender identity specifically as a form of harassment based on sex, not based on gender. They were very clear not to make it synonymous with gender. So I'm not sure why there is that inconsistency. Otherwise, it would be gender/sex here also.
Right, but they're saying, I think what they're saying here is that it's not just based on sex, that it also includes based on gender identity. So you can't just discriminate against me because I'm a woman, but you also can't discriminate against me based on how I identify my gender or my sexual orientation.
I understand the concept, but here the language is defining harassment based on gender identity as a form of harassment based on sex.
Yes,
So
my
harassment on the basis of sex includes discrimination on the basis of gender identity.
My question is, why does it matter?
Because it's inconsistent, and I don't like inconsistency.
What's the inconsistency?
I can repeat it, but I don't know what value that adds. Here they're saying that gender identity include discrimination based on sex includes discrimination based on gender identity.
Right.
Not based on gender. So gender/sex makes them synonymous. So if they are synonymous in one policy, why are they not synonymous in a subsequent policy?
I guess I just don't see the inconsistency.
Okay, so then why doesn't it say gender/sex? I mean, just the words are inconsistent.
So Ken, really, if we took out the word gender on page 2 of,
If you put a comma in there, and that solves it. Then it's no longer synonymous. It's a separate concept.
The only thing I'm afraid of is that if we change that, and if the Public Act is listed like that, I don't think we should change. If you change in one place, right, you don't want to have a place where we don't have in front of us right now and need to change it somewhere else.
Agreed.
I just don't see it as inconsistent. I don't reach that conclusion.
Okay. I mean, the words are not the same, therefore it's inconsistent. I mean, if you just want to go on a basic, it doesn't say gender/sex, which means that it's not consistent with the prior policy, which does mention gender/sex. I mean, to put it simply, without even digging too far into the actual meaning or the actual intent.
Perhaps, Dr. Sylvia, you think we could just ask Rebecca to make sure that, to see if there's any more clarity she could add? I know we do have one more policy to get to this evening, and it's 7:55.
so I just want to make sure though, so there's one space in all the policies. There's one space where it's gender/sex. That's the only one, right?
I believe so. I can go back.
that I could see, there's that second page, last paragraph is the only one that has the gender/sex. Everywhere else, it basically says sex.
I thought I saw two examples. Like I'm missing it now. But it may have
So
been the
in
same policy.
policy 4118.11, it says gender/sex. In 5145.4, it says gender/sex. And in, there was 05.
There it is.
So
And-
is the question whether or not they're synonymous, or is there a different question?
That's the
Like, in
question.
other words, if the question is, are these two words synonymous? And the answer is yes. Do you then want to go add gender/sex to all the other policies?
Or why is it not? More the question would be, why is it listed one way in one policy and listed another way in another policy?
Doesn't slash mean or? Doesn't mean they're the same. It means or.
That's what I'm thinking. I think that's what they meant. That's why when they list in the second paragraph, race, color, religion, age, sex, they don't put gender because it's gender or gender/sex. So I think
in this case, also a comma means or too.
I think it actually means both or either.
Right. But either way, I know Tom doesn't like the word inconsistent, but either way, it's not the same in both and all the policies. And all, yeah. So if there's a reason that it's not, that, okay, I don't know what that might be.
all right. Okay.
So let's just say that it is inconsistent. Do we want to go make it consistent? Is that the question? Like, do we want to go back to the other policies and change it just so that I can make sure that I direct my question the right way?
Is far from the way that I'm reading this and interpreting that the gender and sex are separate and shouldn't be. So if there's a comma between gender, comma, sex, comma, gender identity, comma, then that makes sense in the writing of it. And then if it is the same, then it just takes away the whole discussion. But joining them and then not joining them subsequently, like why is it a similar concept in one but not the similar concept in a subsequent or in another policy? So the one we're just looking at, 514.5, the implication of that is that they're separate because it doesn't say harassment on the basis of gender/sex includes gender identity or sexual orientation. So to me, that means they're separate.
Okay, well, I'll ask the question.
Thank you.
Thank you.
Okay. So next policy up, health assessments, oral health assessments, RPS policy 5141.3. So last time we made a recommendation to remove section 7 since the language now appears in the student privacy policy. But since then, Council has advised us not to delete section 7 in this policy, but to add more clarifying language. Dr. De Silva, did you want to add anything here?
So the recommendation continues to be to keep it as it is. However, there was a question of whether or not we could make the reference to PPRA as opposed to having it all written out the way that it's written out. The reality is it's the same. You refer to something that essentially gives you more of a description than you just putting the description in the policy itself. But we can. In other words, that was the question: is can we do that? Can we just make the reference to PPRA in that we follow the PPRA requirements? We can do that, but it's basically this. It's the same.
Well, the optics of it are different, though. And I'm presuming it was Rebecca.
Yeah.
Did she say why she preferred to have the language in there?
Because it was clear. So now you're going to have, it was just as I think Tom may have described in one of our earlier meetings, is that you're now making a reference to something that they now need to go look up, when in fact you could have just written it. And so why would we not just write it if that's what it is? That said, can we just make reference? We can, and we'd still be following the law and not impacting our ability to have any funding or anything else. So we absolutely can, but you're just really now as a parent, if I want to go find out more, I need to go look up PPRA to find out more. So you're right. There's an optic piece of it, Ken.
And I think that was the challenge with this particular.
Question. This policy, which apparently has caused so much controversy, my understanding, this has been in effect for a number of years, right?
It has, yeah.
That's true.
For 7 years about?
Yes.
So has there been a single complaint by a parent or a guardian for a child since this policy was instituted 7 years ago, where an inappropriate, non-emergency invasive examination or screening took place? Has there ever been a complaint lodged by a parent or a guardian or a student involving this policy to anyone's knowledge?
No, but the reality is because we have not engaged in any non-emergency invasive physical examination or screening as it's defined.
Right.
So no, Tom, the answer to that is no.
But
I
that
think
also-
the other part that makes it, I think, frightening for families though, is that where it's located, right? Because it's located within the health assessment screenings and oral health assessments, it feels, to your point, Ken, it feels like this is something we do because it's within that policy around health assessments, right? So I think from an optics perspective, it doesn't feel like this is here because of our privacy laws that protect parents and students, but rather it's something that we do, which in fact it's not. So I think that's a piece of it. It's just where it happens to be located.
Does that mean
I would agree.
has its location changed? I'm just curious why, if anyone knows, if this has been in effect for so many years, why is it now becoming such a point of contention?
That's a good question, Rachel. Do you know offhand if if the other exemptions other non-emergencies was in the health assessments before?
It was in 2015 when it was approved.
But
the
still
first
under
time.
the same category, right?
Still under the same category, correct?
So I just had a couple points. One, Tom, to that point, it's people that literally approved this inclusion back then are ones complaining about it now. So sort of to further the point that you were making.
Well, why is that though? I don't know.
They're paying attention to the language now.
Because parents are more suspicious now. Health is, there's more conspiracy theories out there now.
It doesn't.
People
it
are
doesn't
more
even have to be a
suspicious and they've
conspiracy
been
theory.
stirred up.
Well, it doesn't have to be
They've been
conspiracy
stirred up
theory.
more.
So our ideas of gender fluidity and sexual orientation have changed in the last 7 years. So it evolves. I would take it. The second thing I would is my personal preference is to leave the language there. To your point, Dr. De Silva, and one that Tom made in an earlier meeting. It's much easier from my perspective as a parent to see the writing in the policy. However, if it doesn't change our liability, if it doesn't change the things that we're responsible for based on public sentiment, I mean, I think that it makes sense to include the reference as long as Shipman and Goodwin approve it. So again, those are my two opinions. I think we should leave it in personally, but I think the community, for the community's sake, I think it's better that we make reference.
I do think that we should only have an opt-in.
We changed that. That's how the
Yeah,
language.
yeah.
That, yeah,
Okay.
we've already
Those are-
changed that.
Right.
Yeah.
Right. That's definitely, I mean, I think that that's definitely good. I mean, as a parent, I definitely would prefer saying that for sure.
I think we
I
definitely,
think we all like, yeah, I know. I just would like to keep it that way.
Yeah, no. Good point.
So
And
I think
just,
we're all tired of opting out of everything, right?
yeah. And just to be clear, is that this isn't something that parents would have to look for throughout the year to opt in even, because the way in which this is described, it's that the district, you know, at the start of each year or at minimum would always have to provide prior notice. So it's not something that I'm going to be on the lookout that's going to be happening or could be happening in my school community. That's just not a reality. And just to clarify, this policy was already approved, Rachel. I think we just came back to committee to take a look at that language again, right?
correct, yes, yes. We were asked just to look at it again in the lens of the robust conversation we had at the board. And on our March 1st meeting, I did go through the history of PPRA and where this language came from through history. We did go through that. And I also went through this entire policy again from beginning to end with comparing it to our health record, which is, to your point, Dr. De Silva, might be optically what some parents might be struggling with, right? Is that, you know, you take our health assessment record and you bring that to your doctor in the beginning of the year for a physical and you get it filled out. That's basically what this policy is about. But then you get to this last subsection 7, and it has to do with the Pupil Protection Rights Amendment, where it's not something that we are doing as a district. So I mean, I think we have 2 options in front of us to bring forth to the full board, right? We could leave this language in here. We could add more language to it. And, you know, I did come up with something. We could add in accordance. Now, the language that I put together is actually I adopted it from our student privacy policy. So we could put something in here like, in accordance with federal law, the Ridgefield Board of Education, the board, adopts, in consultation with parents, provisions relating to student privacy, PPRA. The following provision in this subsection refers to section 7 of policy, section 4 of policy 5125.1, student privacy as per the Protection of Pupil Rights Amendment, PPRA. We could put something like that before this so that parents know where it's coming from. Because right now they don't know. If you start reading this, right, you don't know that this is the PPRA. So we could put that in to clarify the language further.
I think that's an excellent suggestion with very good language.
Thank you. Thank you, Tom.
I agree. It frames it.
Thank you.
Is this the language, the language we're looking at here, this red line, is that the language that was approved? Or has there been something added to that since we approved it?
The blue language in the current policy is the language that was approved.
Okay.
Which includes the opt-in only.
Right,
Mhm.
right, right.
Correct.
Yeah, I like that suggestion, Rachel.
Good.
What is it? I mean, the parents are right when they say that some of this language is kind of graphic and shocking, right? So I think that Rachel's suggestion is a very good one.
Thank you.
Yeah, I think we're all in agreement. We're all in agreement, Rachel, that's go for that. That's great.
Thank you.
I think that
Thank
would
you.
make everybody much more comfortable.
I hope so. I really do.
I was wondering whether we've ever done this as a board. I don't remember it all the years I've lived here, where the board would ever issue a statement with advice of counsel, of course, or the administration, some notice to ease concern about this, to sort of talk plain language about it, just to send it out to the community, because it seems like it's stirring up controversy, and I get it, but people are worrying themselves. So just a suggestion.
I do think, Tom, that the Board of Education meeting was helpful in helping families understand where this was coming from. But I still think that anyone who's reading this out of context or not with that context is still going to feel alarmed that this is even a possibility. And really, again, just to go back to the spirit of what PPRA is, which is to really protect parents and children from any type of invasive procedure being done without them receiving notice. And I think some of the changes that Rachel's suggesting tonight and the changes that we've made since we brought this back to the board, even though it was approved back in 2015, which includes that opt-in, adds that level of security. But all it's going to take is a new parent reading the policy again for the first time. And they're going to be like, wait a minute, what is this? And that's natural. I think it's a natural feeling that people would have reading this without having that context. So, hopefully that it has, I think for many of our families, I think they are feeling more comfortable now, understanding that this isn't something that would just happen. And in fact, we've discussed on several occasions, we can't really, and Aaron's here for this reason and this reason only, but we really can't imagine any type of situation where this policy would apply. But what it does do is that families need to know none of this would ever happen without them being a part of that process and opting in.
Correct. Great. Ken?
I agree. I think the opt-in piece was the important one to winning over the majority of the parents. That was a very good ad. And I think adding your framing paragraph at the beginning, Rachel, I think further goes to sort of the point that we're making of including this language in the first place. So instead of just including a reference to the Privacy Act, we're listing it here. And instead of the parent having to go, oh, well, if this is from the Privacy Act, let me go look up the Privacy Act. Which act is this? We're putting that at the very top. So it's just furthering that transparency, which I think is a good thing.
Now, just to, maybe we don't do this now, but just as an aside, we could, in theory, not even have this here. I mean, we could just simply say, where it says other non-emergency invasive physical examinations and screenings, we could just use the language that Rachel is describing, or at least part of that language that refers to PPRA, and that's all. Because in reality, it isn't something that's done in a traditional health assessment or a screening or oral health assessment. So we could do that as well. We don't have to actually even have it, as long as we have reference to PPRA, that we're in compliance with PPRA.
I like both. Just my opinion.
I think we bring both recommendations forward and have board discussion, full board, and get people to weigh in on their opinion. What does committee feel? Is that good to bring both forward, right? Because it's been such a robust conversation.
Yeah, I would hate for anybody to think that we were trying to hide the policy. To me, that would be really kind of creepy. So I think it would be good to bring both forward, like you said, Rachel.
Well, no change could be made without the vote of the full board.
Yeah.
So,
Yeah, I think that's a good idea.
we couldn't change the language.
You don't want anybody to think we're hiding. Then it does look sinister, for sure.
Mm-hmm.
But perhaps we can, I don't know how the procedures work, but I don't know that, can we bring it back for like a second and a half read? Or do we, if we change that language, do we have to do a first read and then bring it back for a second read to vote?
I think I'm going to have confidence in the 9 of us to make a decision at a first read. Perhaps we can have 2 versions ready for a first read and then, move forward with life.
I don't want to tick off Robert and his rules of order. So.
Oh, I see your point, Ken.
Yeah. So the two choices would be adding that framing paragraph
right before this,
or just adding a version of that framing paragraph.
Correct.
Not having this.
I think there theoretically could be 3 choices. You could leave it exactly the way it is, because that's the way it was approved by the board on the 14th, Valentine's Day. That's 1. 2, you could add that framing paragraph that Rachel just described to what's already here to give families a little bit more context on where it's driven. Or the reality is you don't need to even have it here, and you could just have any, reference to the title, and then reference to our compliance with PPRA, and you don't have to have any of that language there at all.
My opinion on that is I would rather do something than nothing. So if we're bringing it back to the board, it has to be for a change because we've already approved it. So I think the decision tonight is there's really only, if we're going back to the board, it's really for 2 decisions. If we're not going back to the board, I don't think we need to go back to the board to get them to approve something they've already approved. So if we're going back to the board, it's with those 2 choices that we mentioned. And so I think in committee, I think we have to make the decision tonight. Do we want to bring it back to the board with those 2 options or leave it as is?
I would bring it back with 2 options.
Me too.
Agreed.
Okay.
Agreed. I agree.
Any other questions, feedback? Okay. Administration, would you like to add anything before I call for a motion to adjourn?
No, thank you, Rachel. Did a nice job. It's a lot
Thank
of
you so
policies.
much. All of you, thank you so much. This was such a productive meeting. Great questions, great feedback. I appreciate all the hard work of this committee. So motion to adjourn?
I so move.
Okay, Ken, second? Tom? All right, 8:20. Have a wonderful evening. Thank you so much, everybody. Bye.
Thank you, Rachel.